speaker for today and all the attendees to this webinar on understanding same-sex marriage. In the middle of the Pride Month, it is crucial for us as a society to reflect upon the powerful words of Evelyn Goldson. As I state, marriage equality means that all couples, regardless of their gender or sexual orientation, can experience the joy, commitment, and legal benefits that comes with marriage. These words compresses the sense of human rights, emphasizing the fundamental right to love and marry whomever one chooses. Pride Month holds significant relevance as a time of celebrations, reflection, and advocacy for the LGBTQ plus community worldwide. It traces its origin back to the Stonewall riots in the New York City, a series of demonstrations in June 1969 that marked a turning point in the fight for LGBTQ plus rights. It raises awareness about the challenges that the community continues to face, inspiring conversations and action towards greater acceptance and reality. In this particular aspect, confusion arises surrounding the concept of same sex marriage. It is essential for us to approach this topic with an open mind, respect for diverse perspectives, and a genuine desire to learn and understand. By engaging in discussions and seeking a deeper understanding of the social, legal, and personal dimensions of same sex marriage, we can overcome the confusion and promote a more inclusive and compassionate society. And for that, we have Sir with us to enlighten us. I would like to take a moment to introduce our esteemed council now. Wiki is a premier national business chamber for women, envisioning global impact for women entrepreneurs, business women, and professionals from all walks of life, that currently has the backing of over 250,000 members from global and influential women's network, including G100, Women Economic Forum, and She Economy, with a motto to drive fundamental changes in governmental policies, laws, incentives, and entrepreneur ecosystems. The councils and wikis are set up as national, regional, state, city, and bilateral levels, along with three national boards that are governing, advisory, and executive. These boards put forward certain recommendations to relevant government authorities and institutions to empower women owned businesses. We make women's voices heard and their participation count. Amongst them, National Judicial Reform Council, known as NJRC, is a national level council, a non-profit organization under the aegis of the Wiki. We have kick-started a journey in 2021, and today it's a very proud moment for us that we have 9 state and union territory councils formed under NJRC, such as UP JRC, Delhi JRC, Gujarat JRC, Rajasthan JRC, and many more. Our council not only focuses on searching and understanding the lacunas in the judicial system, but also on bridging the gap to ensure speedy delivery of justice. Over the span of 2 years, we have conducted various webinars, panel discussions, competitions, open mic events, and awareness drive under the banner of NGRC. We are a team of 70 council members led by a president, Ms. Aishwarya Bhatia, and vice president, Ms. Devanshi Parash. We all work in enabling fundamental changes in governmental policies, laws, and incentives at all levels to collectively and robustly encourage and empower women in business, industry, and commerce. As we move ahead with the event, it is with utmost honor that I introduce the speaker of the evening, Mr. Deepak Anjana. Sir is an esteemed legal profession with a profound passion for constitutional and human rights law. He holds a Bachelor's of Law degree from the prestigious Institute of Law, Nirma University. Building on his foundation knowledge, he pursued a Master's of Laws degree from the esteemed National Law Institute of University Bhopal to further hone his expertise. Sir's dedication to academia is exemplified by his qualifications in the UGC NET exam. Currently serving as an assistant professor of law at Indore Institute of Law, he continues to shape and inspire the legal minds of tomorrow by sharing his deep understanding of constitutional and human rights law. I would like to request Sir to enlighten our attendees with his profound wisdom and deep knowledge on this issue. Over to you, sir.
Thank you for such a warm welcome. I thank National Judicial Reform Council under the aegis of Wiki for giving me this platform to speak on the topic of understanding same-sex marriage. So, am I audible to you all?
Yes, so you're
Perfect.
perfectly audible and visible.
Yes, sir.
Okay, so why we are discussing this topic today? Because we have a petition filed before Honorable Supreme Court of India, the case of Supriyo Chakrabarti versus Union of India, which is right now pending, and the hearings are going on in this case. So first of all, I'd like to start with the background of the issue, which is homosexuality. When we talk about homosexuality, many people says that it is a Western concept, but I would like to throw some light on the issue and debunk this notion that it is the concept of homosexuality is a peculiarly a Western concept, and we don't have anything like such in our as a part of our civilization. So to start with, we have numerous examples of homosexuality being practiced in India since ancient times. Uh, we have how many of you have most of you have in fact heard about the famous Khajuraho temple in Chhatarpur district of MP, which are known for their erotic art and sculptures. So if you visit those temples, you will see that there are sculptors, numerous sculptures showing homosexuality, the clear depiction of homosexualities, where women and women making love to each other, mains making love to each other. Apart from that, we have examples from Valmiki's Ramayana, where Lord Hanuman says that when he went to went to Lanka to and meet Sita and came back, he said that I've seen women making love there in the Lanka. So we have this one more example. Then we have few other examples from Rig Veda also, where you must have heard about the couple. I forget the name of that couple. Yes, Varun and Mitra. Varun and Mitra are the same-sex couple which have been mentioned in Rig Veda. Then we have you must have heard about the character called Shikhandi in Mahabharata. So there are numerous examples to prove that this the notion or the concept of homosexuality is very much Indian. It is not a Western ideology as said by many, especially few prominent organizations such as RSS, the people from RSS every now and then says that it is typically a Western ideology and we should not accept this. So this first thing that it is homosexuality a Western concept? The clear answer is no. It is not a Western concept. We have numerous examples from our own scriptures, our own architecture to show that yes, it is. It was very much part of our own civilization, Indian civilization. Now, come to the issue. The main issue here in the case of Supriya Chakrabarti is to legalize same-sex marriage. Now, how we reach here? We reach here because of the judgment of Navtej Johar in 2018, where Supreme Court decriminalizes same-sex between consenting adult in private. That is, it read down Section 377 of IPC to an extent that it criminalizes same-sex between consenting adults. So after that judgment, there were talks that now what? The half battle has been won, and the LGBT community celebrated their judgment. But what after that? Is it the decriminalization of Section 377 uh, is enough, or something more need to be done? The answer is definitely something more need to be done. Mere decriminalizing same-sex marriage won't make the LGBT community equal citizens of this country. Now we have to understand why they are demanding legalization of same-sex marriage. If we see Indian society, though we are highly tolerant society, we our civilization is known for that. But at the same time, there are examples of highly superstitious uh, notion which we have. The mainstream society don't consider. Is there some? Hello.
Yes, so you can
Yes.
continue. I think.
Yes. The mainstream society consider LGBT community as the other. They don't consider themselves the part. They don't even consider them equal human beings. So the notion has to be changed. First of all, they are as equal citizens of this country as other people are, as so-called straight people are. So they are equal citizens of the country, and they are protected by the constitution itself. So first we have to change this notion that this minority community of LGBT people, and they have some different habits which are peculiar to the mainstream society, and therefore we should be treat them differently. No, they are first of all human beings. They are gift of god like all other are, and after apart from that, they are equal members of the union of india, that is bharat. They possess equal citizenship as other people possess, so they should enjoy all other rights which the non-lgbt community or the straight so-called straight people or the mainstream society enjoys. They also are they also entitled to all those rights which the mainstream society enjoys. So because of that, this petition was filed in the in the honorable before honorable court of india, supreme court of india. Before this petition, there are various petitions filed across various high courts such as kerala, if I'm not wrong, karnataka high court. There are numerous high courts before which such petitions have been filed. Now, why same-sex marriage need to be recognized, why it need to be legalized? Because every individual under article 21 of the constitution enjoys liberty, personal liberty and right to privacy. As you must be knowing, as most of you are from law background, you must be knowing about Puttoswamy judgment, K. Puttoswamy judgment, which came back in 2017, which recognized right to privacy as fundamental right under Article 21 of the Constitution. So we have this Puttoswamy judgment, which says that privacy forms part of Article 21. So, before that, there are various judgments which says that right to dignified life forms part of right to life. So if we don't give them equal rights, if we don't give the homosexual community or lgbt community equal rights, then they will their life will not be a dignified life. Their life, they will not have their personal liberty to enjoy the life as they wish. So if the same-sex marriage is not recognized, as the situation right now is, it has not been recognized, it has not been legal right now. So what rights of those communities are being infringed at present? Which and the rights are, first of all, article 14, which talks about right to equality. Everyone is equal before the law. The second one is Article 15, which talks about prohibition of discrimination on the basis of various things such as caste, race, religion, and sex, and other similar things. So now we talk about sex. So in Navtej Johar case, it has been held by the Honorable Supreme Court that sexual orientation is part of the term sex, which has been used under Article 15 of the Constitution. First of all, second thing, it sexual orientation is a part of freedom of expression under Article 19(1)(a), sorry, 19(1)(a) of the Constitution. So at present, if the legal same-sex marriage is not been legalized, then their rights under article 14, under article 15, under article 19(1)(a), under article 21 of the constitution would be infringed. They are right now being infringed on daily basis, because they can't enjoy their life as other people do. They suffer discrimination at the hands of society, which is known to everyone. But if it is not, where the same-sex marriage has been not been legalized, they would suffer, or are suffering, in fact are suffering discrimination, on legal discrimination also on the part of state. So hope you have understand the background why they are demanding legalization of same-sex marriage. Now, what is the issue present in the case, in the Supriya Chakrabarti case? They are demanding legalization of same-sex marriage or recognition of same-sex marriage under Section 4 of Special Marriage Act. You might have heard about it, Special Marriage Act. Under it, it is a secular law under which people belonging to different faiths can register their marriage and get their marriage legally recognized. So, what special marriage talks about? Now, the catchword here is it is a special legislation, first of all. The petition are not demanding recognition of same-sex marriage under any personal law, such as Hindu Marriage Act or Shariat Act. They are not demanding recognition of the same-sex marriage under any personal law because the personal law won't recognize such kind of marriage. So what they are demanding? They are demanding recognition under Special Marriage Act, which is a secular law. Now, if you look at the long title of Special Marriage Act, Special Marriage Act का long title है, it says that, let me quote the long title as it is. Yes, an act to provide. I am reading the long title of Special Marriage Act. It is an act to provide a special form of marriage in certain cases. So what does it talks about? It talks about special form of marriage. Now, what does special form of marriage signify? It signifies that marriage of special kind. Special kind might include same-sex marriage. So the long title of the act suggests that the Special Marriage Act is a the long title suggests it is a wider term. It caters to the needs of even homosexual couples. Further, further, apart from this, there is Section 4C, subclause C, which says that a legal age for marriage for male is 21 and for female it is 18. So it is indirectly suggesting that marriage should be between man and woman. So what the petition is demanding that under Special Marriage Act, the marriage should be made neutral, gender neutral, so that even homosexual couples such as gays and lesbians can register their marriage. So hope you have got the basic crux of the what the petition is demanding in this Supriyo Chakrabarti versus Union of India case. Am I clear? Now, I'll come at there is some problem with Special Marriage Act. There is a notice regime under Section 6, 7, 8, and 8 of Special Marriage Act, towards which I'll come at the end of this session, which the petitioner have not demanded. And I'll throw some light on that issue towards the end of the judgment. Now, we are clear with first thing that it is not a Western concept. It is very much part of our civilization. The second thing, what the petition or what the Supriya case prayer involved, what they are pleading. Now, if we look at the judgment, Navte Johar judgment, you might have read about this judgment. What the basic premise of the judgment? It says that every individual, including LGBT community, are human beings and enjoy. They are entitled to same rights as other people enjoy. Okay, ठीक है. So now the thing is, the second question is, first is it is not a Western concept. The second is, lot of people termed it as a disease. People call that this homosexuality is a disease and it should be cured. So in answer to this question, Indian Psychiatric Association in 2018 itself clearly stated in its report that homosexuality is not a disease at all. Second thing, the sexual orientation. There is no scientific study up till now which can prove that sexual orientation can be changed. So the next thing is, some people say that if we legalized same-sex marriage, then the number of LGBT homosexual peoples will increase if we legalize same-sex marriage. But it is not possible because you cannot change the sexual orientation of a person. It is something which is very innate, which is very something personal to an individual. It cannot be changed overnight. So if an RSS spokesperson says, for example, that if we legalize same-sex marriage, then the number of these people in the community will increase and it will create problem for the society, for the mainstream society. But There are no scientific evidence of it to prove that you can change the sexual orientation of person. It and this is the report published by Indian Psychiatric Association. Similarly, there is American Psychiatric Association, which also says that it is not a mental disease, it is not at all a disorder, it is very something very personal, which depends on person to person, and it is part of his life and personal liberty. No one can force another person to change his sexual orientation. It comes from within. So this second argument, that it will the legalizing of same-sex marriage would increase number of these people, it is not at all tenable. It is not backed by any scientific proof. Am I clear up till here? Yes. So the next question,
Yes, sir.
next issue involved here is whether it is against the nature. Some people call it that it is unnatural and it goes against the very natural laws. But if something is prevalent in society since ages, how can it be unnatural? In fact, the laws such as Section 377 has been brought by Britishers when India was colony to British. This notion of criminalizing homosexuality was not part of Indian culture, as it was prevalent in India, in the Indian civilization, and I had given ample of examples to you of ancient history. So it is part of Indian civilization. It is not against nature. It is prevalent since ages. In fact, by criminalizing such activity, such acts of homosexuality, it is the hegemony of British era, which has been imposed on its colonies. Similar example we can find from South American countries, which was, South American continent is was a colony of Spain. So there too also the laws criminalizing homosexuality has been brought by the imperial regimes like India. So this the concept of criminalizing such act has been imposed upon us by colonizers. Second thing, they why they do so, because it is based on the traditional Christian belief, the traditional Catholic Christian belief that it is against the order of nature. So they penalizes things such as sodomy, homosexualities since ages. So in this, the concept of penalizing homosexuality is not of Indian origin. In fact, it is the hegemony of colonial rule. India, and there are various examples in South America, India, who and Africa also, who were colonies of the European powers. Now, if we come to the, I have dealt three issues. Am I clear up till now? No.
Yes, sir.
What if suppose if we don't legalize same-sex marriage? What would be its impact on the homosexual community or the LGBT community? Would the Navtej Johar judgment would be of any significance? I guess the clear answer is no. If we don't legalize same-sex marriage, then the couple won't enjoy, the homosexual couple won't enjoy the rights enjoyed by heterosexual couples, such as rights of succession, rights of adoption, and various other rights which are associated with spouse, such as for simple for that matter, joint bank account for that matter, or nominee in policy for that matter, some insurance policy, life insurance policy. So heterogeneous couples or heterosexual couples enjoy a lot of rights because their marital status has been recognized by the law. The same rights won't be enjoyed by the homosexual couples, which would be against, totally against the ethos of the constitution. It would go against the basic values of the constitution, which I have quoted beforehand. It will violate various rights of the constitution in part 3, fundamental rights. Now, the thing is, there are there is a concept of constitutional morality as well as societal morality. What is constitutional morality? It is the moral principles and values that flows out of constitution itself, that flows out of especially part 3 and part 4 of the constitution itself. So here, the present case of whether to legalize or not legalize the same sex marriage involves a tussle between constitutional morality and societal morality. अब societal morality क्या होती है? It is the moral principles and values which a society possess. It termed as societal morality. So the present situation involves a tussle between constitutional morality and societal morality. So in this case, if we go with the societal morality, then the LGBT community, which is a minority community, would suffer. Why it would suffer? It would suffer because they would not enjoy the right to life and they can't have basic dignified life with which the heterosexual couple is enjoying from since ages. Now, if the thing is, if they don't have all these rights, then their life would not be a life of quality. They have to suffer at the hands of establishment as well as at the hands of society at large. Now, let me come to the issue. Another issue. The next issue is there is a state legitimate interest in of the state. When the union government, in its reply to the petition in Supriya Chakrabarti case, says that there are legitimate state interest involved in the present issue. If we legalize same-sex marriage, then it would have repercussions because all our personal laws were such as related to adoption, succession, marriage, maintenance, divorce, are not gender neutral as of now. So if we legalize same-sex marriage, there would be problem implementing the laws, gender neutral laws, and which is a genuine reason on the part of state. There is no denial in that because overnight you can, if tomorrow, for example, the Supreme Court recognizes same-sex marriage in the country. So with that, there comes a plethora of laws dealing with succession, adoption, divorce, maintenance, which need to be changed, and which is the domain of parliament. Making laws and changing laws is the domain of parliament. So if overnight decision of the Supreme Court recognizing or legalizing same-sex marriage would have repercussions in the domain of personal laws such as Hindu Succession Act, Adoption Act, Sharia Act. There are act for Parsis to govern. There are Christians are governed by their own personal laws. So it would have repercussions. So what to do now? There is a serious problem, and it is a genuine argument presented by Union of India that what about those laws which cannot be changed overnight. So it's better the center is asked or Union of India is asked so to let this thing to be decided by the parliament or legislature itself rather than judiciary giving decision upon this issue. Now if we buy the center's argument, then what centers do, what the legislature represents the will of the people. And if we see the majority of people of this country right now won't support such act or legalization of same-sex marriage. They are against this notion. And it is a fact they have their own opinion. We are a democratic country. Constitution provides you the right to freedom of speech and expression. You can have your own notions and your own uh, take on particular topic. So majority of people will would not support legalization of same-sex marriage through a legislation or through law by parliament. So I don't think Parliament would pass any such act in near future. I guess it might take another 50 to 100 years to do so. So what if we left it in the domain of Parliament? Parliament will not do anything because it will depend. It represents the Benthamite concept, welfare of the majority of the people. What Jeremy Bentham talks about. So if we go by this, Parliament won't make any law in near future on this topic. Now, a lot of people are shocked by this that how can Supreme Court because up till now the stance of Supreme Court is towards the LGBT community as it has already decriminalized the same sex between adults in private. So what is there are a lot of speculation that Supreme Court will soon recognize this and it will create problem for society like traditional society like India. But the same thing had happened initially. Remember, after a bit 2 centuries before, when the widow remarriage bill was brought, when the widow remarriage was allowed in 1850s by the British government, supported by various activists such as Ishwar Vidyasagar. The same hue and cry was made initially in the 18th and 19th century when sati was abolished. So during that time also, the society was not ready to accept this radical change. It is the society initially resist such kind of change which are not perceived correct by majority of the community. But now if we see the widow remarriage act, sati abolition act, it was correct step taken that time by British government. It was because it was necessary for upliftment of women and women empowerment, and to give women equal rights in the society. Similarly, if we see the current situation, like that society revolted against that time. That time also there was a lot of hue and cry. There were protests across various areas of the country, especially the Bengal, which was epicenter for widow remarriage act, widow remarriage rights. So there were protests, there were street protests involved, there were a lot of hue and cry. Similarly, at present also there is a lot of hue and cry. Majority of section don't support this. They see this as a disease. So society changes, the moral values changes, it is not constant. Today the widow remarriage thing is very normal. Today the women and or girls going to the college or schools and attending their lectures and getting degrees and contributing in the growth of the country is very normal. But 100 years or 200 100 years before that, it was a very radical thing. Similarly, what presently what the LGBT community is demanding seems radical to a lot of people. But 50 years down the line, suppose 50 or 100 years down the line, our progeny will say that why there was a lot of hue and cry with this thing. It is a very normal thing, and people should have enjoy. Even homosexual couple, they are they too are human being, and they should enjoy all these rights which the heterosexual couples enjoy. So the societal morality, the moral values of the society and principles are not constant. They are evolving and changing with changing times. So if the question comes before the Supreme Court whether to go with the constitutional morality. Now some of you might think what this constitutional morality is. Let me state that what this constitutional morality includes. Constitutional morality are the ideals and morals of the constitution and the values that create an inclusive society. So the constitutional morality are the moral values or ideas that flow from the constitution itself, not from the society. And it talks about inclusive society, which says that there should be inclusiveness, and everyone should accept the uh, differences. We should accept and celebrate the differences. So it is the basic premise of constitutional morality. So now in this case, the court, I think the court should go with constitutional morality rather than going with societal morality. Because if the court goes with the societal morality and popular opinion, then a section of the society would not have their right to life as they want to enjoy. They will not have a dignified life, neither they will have a personal liberty to enjoy their life. Their life would be like animal existence. They are just living. But that life is not what dreamed by the founder of our constitution, and neither uh, as a civilization we should dream of this life. So if the societal morality supersede the constitutional morality, then it would have negative repercussions for the LGBT community, which is no matter पिछले कई जनरेशन से कई सेंचुरी से वो सफर कर रही है. सो सिर्फ क्या उनको डिक्रिमिनलाइज कर देना सेक्शन 377 को इज नॉट इनफ. It is important and need of the hour are to legalize same-sex marriage. Otherwise, it would be a futile exercise. Now, Navte Johar would not mean anything unless and until the same-sex marriage is legalized. Now, am I making sense up till now?
Yes, sir.
Yes. The next thing is, excuse me for a second. The next and most important thing which I found bizarre in this petition, which this the petitioner should have raised this issue, is section 6, 7, and 8 of Special Marriage Act. Now, what are they? they talked about the current law under the Special Marriage Act is, if a couple wants to register their marriage under Special Marriage Act, they have to go to the marriage registrar under appointed under Special Marriage Act, and they have to show their intention to marry. Now, before issuing them the marriage registration, uh, 1 month notice is to be given to the marriage officer who is authorized to register the marriage. Now, it is not the case with marriage with heterosexual couples. Under personal laws, under personal law, it is no such thing. You can marry, and you can, after marriage, you can go and you can have your marriage registered within 1 or 2 days. It is not a lengthy process. But in case of Special Marriage Act, if one wants to register their marriage under Special Marriage Act, they have to give prior 1 month notice. Second thing, the notice regarding their marriage should be pasted or published by the registration marriage officer at various places in the vicinity of that registrar office, that so and so people are or so and so people wish to marriage under Special Marriage Act, and this is their name and this is their address. Now, what this will do, this thing will create more trouble for the couple who want to get married under Special Marriage Act. Already, interfaith couples in our society are facing trouble in getting their marriage registered. They are harassed by the society, they are harassed by the moral police of the society. If there are interfaith couples, then they have to face a lot of trouble in get their marriage registered. There is security, there is threat to their life. You must have seen NH10, a movie, NH10 movie of Anushka Sharma. It is a very good movie. You must watch it. It is based on honor killing. So there are a lot of instances of honor killing in our society. If a girl goes against the wishes of her parents and marries a person from other faith, in fact other caste also, then the repercussions would be very harsh for her or him. So already there are a lot of problem for interfaith couple. There is issue of harassment, there is issue of privacy, there is issue of security to their life. And considering this thing, then this notice requirement under Special Marriage Act would make situation for them more worst. Are you getting it? This notice requirement for conditions under Special Marriage Act make situation more worse. So the same would apply in case of same-sex couple. Suppose if the court recognizes or legalizes the same-sex marriage under Special Marriage Act, suppose from tomorrow onwards, the same-sex couple can register their marriage under Special Marriage Act, but they too have to go through the same procedure and the regarding notice and publication of the that so and so people are interested to marry and all these things. So it will make situation more troublesome for them. So apart from just legalizing same-sex marriage, what is the need of the hour is to do away with this notice regime, which under section 6, 7, and 8 of Special Marriage Act. Because until this the we until the legislation amend this laws, the condition or the situation or the environment for the same-sex couple to get married peacefully would not be better, or would be what I would say, बहुत खराब हो जाएगी situation उन लोगों के लिए. They will be harassed by the society, they will harassed by the moral police, the so-called protector of Indian tradition, and they will be harassed by the state itself. So there is a need to change this notice regime under Special Marriage Act. So I don't know why these petitions have not raised this issue, which is the need of the hour. So this is the thing which should be taken care. The court, if suo moto, if the court wants, or someone files a petition with this regard, the provisions of Special Marriage Act need to be changed. Apart from legalizing same-sex marriage, there are some changes need to be made pertaining to notice requirement under same-sex marriage, so that they are not harassed and there is no threat to their life and personal liberty and privacy as well as security. So yes, apart from this, am I clear with this notice aspect and why it need to be changed?
Yes, sir.
Yes. People who are attending it, yes, give a thumbs up. Okay, so that I can uh, uh, okay, there are a lot of thumbs up, then it means I am making sense to you. Thank you. Now the thing is, as of now there are 34 countries which have legalized same-sex marriage. and most of these countries are Western countries, South American countries, North American countries, and Western European countries. And in South Africa, in African continent, there is only South Africa which has legalized, and in Asia, as far as I remember, if I'm not wrong, only Taiwan which has legalized same-sex marriage. If you go south, then there is Australia and New Zealand which have recognized same-sex marriage. So lot of countries with passing time are recognizing same-sex marriage. And if we talk about the data regarding the countries which have still criminalized the homosexual activities are 57. 57 countries, mainly Asian countries, Middle East countries, which have still criminalizes, which still the law of those countries still criminalizes homosexualities. So out of 193 registered countries with United Nations, only 57 countries still criminalizes homosexualities, and 34 countries legalized same-sex marriage. So it is the need of the hour to it is the need of the hour for us to legalize same-sex marriage. It will not only promote our constitutional values, but it will also promote respect for international laws. You might have heard about Universal Declaration of Human Rights. You might have heard about ICCPR, ICACR. They all promote personal liberty, right to life, and dignified life. So it will not just promote municipal laws, but it will also implement international laws, though some of which are not binding in nature, but it will shows India's commitment and determination towards promoting rights of minorities. Minorities means I'm talking about LGBT communities, which is a minority community. Now, the notion of third gender, there is also notion of third gender, in which the Nalsa judgment, you might have heard about it in 2013, recognized that transgender should be says that transgender should be recognized as third gender. So if we talk about homosexuality, we only what strike to us is just lesbians and gays. We forgot about transgenders. They too are human beings. They too are human beings. They too can. They too have rights to live with dignity and enjoy their personal liberties. So this the aspect about transgender should also be considered. When we say LGBT community, it is LGBTQ plus. It is not just LGBT. So there are a lot of variations included in this. There are, you might have heard the term about uh, asexual, bisexual. There is also a term called pansexual. Now, what is pansexual? It means those who are attracted towards all the genders, whether it is bisexual, whether it is transgender, whether it is homosexual, or whether it is heterosexual. Individual can get attracted towards various other sections, areas, various other genders. So when we talk about the rights of LGBT community, not just lesbians and gays form part of it. There are various categories which should be protected, and which should be given the right to life with dignity. Now, there is a good step with this regard by the government, by the legislature. There is a transgender bill, Transgender Act of 2019, which talks about the various rights of transgender person. But it is not enough. A lot of things need to be done for protection and promotion of those rights also. So when we talk about this homosexuality, transgender should not be forgotten person. Our focus should not just be upon gays and lesbians, but it should include all the aspects covering LGBT community. I guess I have made my point clear. I don't think anything left from my side to discuss. Yes, huh. The last thing which I want to discuss is, now I said that there is an issue. There is a legitimate state interest and valid point raised by union when it says that if you if you legalize same-sex marriage at one stroke, then it will have problem in implementation, because there are a lot of allied laws need to be changed, which I have discussed, such as adoption, succession, marriage, divorce, and a lot of things. They have to be made gender neutral. At present they are not gender neutral, but if the court recognize same-sex marriage, it has to be made gender neutral. Now, what to be done in that case? I don't think legislature, if the court left this decision of whether to legalize or not to legalize same-sex marriage to legislature, it will do anything for next 100 or 50 or 100 years. It will remain in limbo. Nothing will be done. So what code could be done? This is a genuine case. So we have a precedent in this regard. There is a South African Constitutional Court judgment, which is it was given back in 2005, through which the South African court recognized same-sex marriage in the country of South Africa. Now, the name of the case is Ministry of Home Affairs versus Fori. It is popularly known as Fori judgment. Fori judgment of 2005, which legalizes same-sex marriage in the country of South Africa. Now, what they have done, similar problem was presented before the Honorable Supreme Court of South Africa in that matter. So they have come out with a remedy for this. What they have given, they have given 1 year time to legislature for the time being, so that legislature would amend all the laws pertaining to adoption, divorce, maintenance, and all laws related to marriage, and make the laws gender neutral, so that the जो सेम सेक्स मैरिज वंस गेट लीगलाइज्ड, वो जो लॉज है वो एंजॉय कर सकें। क्योंकि अगर अभी क्या होगा, सेम सेक्स मैरिज तो लीगलाइज हो जाएगी, लेकिन लॉज उस हमारे पास वैसे लॉज नहीं, जेंडर न्यूट्रल लॉज, ठीक है, तो प्रॉब्लम होगी, उससे लिटिगेशन और बढ़ेगा, कंफ्यूजन और क्योस और बढ़ेगा कि कौन हस्बैंड माना जाएगा, किसको वाइफ माना जाएगा। अगर मान लो कोई दो गे कपल है, तो हु वुड बी वाइफ एंड हु वुड बी हस्बैंड, किस तरह से हम इंप्लीमेंट करेंगे लॉज को, बहुत ज्यादा प्रॉब्लम हो जाएगी। तो फौरी केस में क्या किया, कोर्ट ने टाइम दिया किसको, वहां की लेजिस्लेचर को 1 साल का टाइम दिया, एंड सेट कि इस 1 साल में आप जितने भी लॉज हैं ये जो कि मैरिज को गवर्न करते हैं उनको जेंडर न्यूट्रल बना दो, और 1 साल के बाद फिर जो है हम इम्प्लीमेंट, ये जो है जो जजमेंट आज दे रहे जिसमें हम लीगलाइज करें सेम सेक्स मैरिज को, इट विल गेट इम्प्लीमेंटेड आफ्टर एक्सपायरी ऑफ 1 ईयर, ठीक है। और if the legislature fails to do so, then court said that we will prescribe guidelines on our own, and we'll pass the guidelines, and all the laws pertaining to marriage would made gender neutral. So this can be done in present case too, in Supriya Chakrabarti case too, so that the chaos and confusion and litigation which would follow after legal recognition of the same sex marriage could be avoided, because there is a genuine case on the part of state that various marriage related laws would need amendments, and which is the need of the hour. So what Fori had done, Fori had this decree of, in the Fori case is known as suspended declaration of invalidity. It is known as suspended declaration of invalidity, through which the court asked the legislature to pass the laws within 1 year, make them gender neutral, and then our decree will apply, which legalizes same-sex marriage. I guess it is clear to you, the Fori judgment. Yes, I
Yes,
guess
sir.
I have covered all the aspects. Now over to you if anyone has any questions.
Thank you, sir. We'll be taking the questions shortly. That was indeed a very fascinating summary of the complete issue. We came to know a lot about our history, also the historic relevance, the background which you mentioned. And I think the interests of a lot of people are at peak right now. So, the in depth exploration of the topic of same sex marriage has been an enriching and eye opening experience completely. Through the comprehensive information provided by you, sir, we have gained a profound understanding of the legal intricacies surrounding the issue. By delving into the complexities of same sex marriage, we have been able to unravel its legal implications, rights, and societal impact. Understanding the legal framework surrounding same sex marriage has shed light on the struggles faced by the LGBTQ plus community and emphasized the importance of advocating for equal rights and protection for all individuals, irrespective of their sexual orientation or gender identity. Our attendees have gained significant knowledge on the topic of same sex marriage. With your kind permission, sir, I would be honored to open the floor to our audience, inviting them to share the questions and seek further clarity on this subject. I would request the people to please type your questions in the chat box, as this is an excellent opportunity to engage in a meaningful discussion. So, we are looking forward to your questions. Please put it on the chat box.
Yes, I have got a question in the chat box, but it was not complete, I guess.
So we have a question. The attendee particularly seeks your opinion about that people are not aware and they don't have the idea that what is the difference between sex, sexuality, and gender.
Yes.
And like, yes,
Yeah, continue. Complete your question, please.
right, sir. And they feel that, like as you said, the parliament has to put a bill on the table. So they are the legislature famous, and here the attendee believes that they are not even aware. So how are they? How do you think that they're competent in framing laws or protecting the rights of the individuals?
Correct, correct. So the thing is, the majority of our parliament, suppose Lok Sabha has 543 members. If you ask them personally, 99% of them would say that this should not be done. The same-sex marriage should not be legalized. In fact, they would not be happy with the Navtej Johar judgment itself. So the thing is, there is need to educate people on this, and it should start with first home and then the school education system. I know a person personally who is a gay, and he comes from a typical village background. He has been married off to a girl of his parents' choice, and now the girl wants to seek the divorce from that man because he is a gay. But the parents don't know, the community at large, the community at large don't know about that person, that he's gay. But he's frightened to share his sexual orientation with his family. Why? Because family values are not ready to accept it. No one in his family would accept him. They, in fact, people would, its family would, his own family would disown him. This the problem lies here is the acceptance. So first of all, it should be start with school education, and before that, in family itself, the parents should teach their children that, look, there are such kind of people in our society, and they are not and it is not a disease, they are human beings like us only. So the teaching of such values should start from our home itself. Then it should be inculcated into the curriculum of school, into the school curriculum. People should be made aware. Unless and until people have knowledge about it, उन्हें knowledge होगा इसके बारे में कि हाँ, ऐसी कोई चीज होती है, इट इज प्रिटी नॉर्मल, इट इज वेरी नॉर्मल, इट इज नॉट एट ऑल अ डिसीज, एंड इट कैन नॉट बी चेंज, इट इज समथिंग वेरी इनेट, तभी इस चीज को एक्सेप्ट कर पाएंगे. सो वेरी करेक्ट. नॉलेज लोगों में नहीं है, दे आर नॉट अवेयर अबाउट इट, दे सी इट एज अ डिजीज, दे कंसिडर सच पीपल as criminals or a blot on the society. So this thinking needs to be changed. That's why I said, if the Supreme Court give this task of legalizing same-sex marriage to the parliament, I don't think in next 100 year it will be done. That's why it is very important for Supreme Court to intervene here in this case. Yes.
I think that completely answers the query. So we have another question by Kapila. So the question is that, as you mentioned, that same-sex marriage, there are a lot of other aspects in this regard that's related to adoption, maintenance, divorce, and other stuff. So her question is, how will all these things be managed or incorporated after, even if same-sex marriage is legalized?
I know this is very big question. It is a mammoth task. It cannot be answered very shortly. But yes, we can start it in a peaceful way rather than doing it in one stroke. We can start it in a peaceful way, one by one. Suppose adoption laws. What are adoption laws? Laws at present are governed by JJ 2015 and Kara guidelines. You must have heard about it. The law students must have heard about it. So at present, only a married couple can adopt, or a single person can adopt, but not the homosexual cannot adopt. So instead of this law, we can make adoption law gender neutral. Why not allow homosexual couples to adopt them? Now again, there is an issue. I had discussion with a lot of people, and they come with this logic that if the children, homosexual couples are allowed to be adopted, the children's, then it would have negative impact on their upbringing. Now, I mean, it is a bizarre statement I have heard from a lot of people. I don't know how. It says that they will also become gay. They will also turn into a homosexual like their parents. It is a bizarre statement to make. I think there are a lot of people whose parents are heterosexual. So and their children are homosexual there, so there is no relation between upbringing and the homosexuality or heterosexuality of people. So yes, coming to the topic, the lot of need to be changes need to be brought. That's why I said, instead of Supreme Court just passing the judgment and legalizing same-sex marriage, first the laws need to be changed. They need to be made gender neutral. So there are aspects related to succession also. There is a Hindu Succession Act which talks about the laws regarding succession. There is legality regarding marriage. You might have heard about Sapinda relationship, but I'm not going into the marriage, because after all, the demand for legalization of same-sex marriage is under Special Marriage Act. The personal law ambit won't come here. So yes, there is issues regarding succession. There is issues regarding adoption and succession, who would be considered as father and who would be considered as mother. Then there are issues regarding maintenance. You might have read about section 125 of CRPC, which talks about maintenance, which is a secular law. There are also personal laws regarding maintenance, but if we talk about section 125 of CRPC, it also need to be changed. It need to be made gender neutral. So it should be done step by step, and it should not be done in haphazard manner. The legislature should take proper time and analyze the situation and make laws accordingly. I'm saying that it is I agree that it is not an easy task, but इफ ये आर्ग्यूमेंट दे देना कि इस तरह के लॉ बनाने बहुत डिफिकल्ट होंगे, उस बेसिस पे आप कोई चीज सेम सेक्स मैरिज लीगलाइज नहीं कर रहे हो, इट इज नॉट टेनेबल. जस्ट बिकॉज देर इज सम डिफिकल्टी इन मेकिंग लॉ, यू कैन नॉट डिनाई a chunk of people their basic human rights, their basic constitutional rights, because other countries have also done it. Even South Africa, whose example I have just given, it has also made all its laws gender neutral. So if other countries are doing it, why can't we?
Right, so we completely agree with your opinion. So I think you just talked about how there's this dilemma in the society, basically a backward opinion that if the homosexual couples adopt children, so their upbringing will be affected of all that. As a same question has been posed by a attendee, so her question is that how can court tackle this issue of backward opinions where they feel that in case of adoption or in case of where homosexual couples are adopting children, so their preferences will be influenced because of the sexuality of their parents. This completely doesn't make sense.
Yes, that's why I said in my statement, because I know a lot of people who are homosexual, but their parents are not. So there is no scientific study or scientific backing as of now to prove this. It is a mere presumption, and presumption may be wrong.
Right, sir. So another question which we have with us today is that Section 8 of the IPC deals and basically the language which the law states, where they have mentioned pronouns like he and she, which clearly states man and woman. So for what, according to you, what should be the first step? Should the law be changed, the wordings be changed to make it more gender inclusive?
Yes, first of all, the law should be changed first. The law should be made gender neutral, one by one, before legalizing same sex marriage at one stroke. Otherwise, it will increase litigation for the court. It will create a very chaotic situation. So that's why I cited the Fori judgment of South African court. They have devised a very unique method to avoid this chaos and confusion and litigation. Is what allow the legislature some time so that they can make laws gender neutral first, and then Supreme Court legalizes the same-sex marriage. And if the legislature is not willing to do, then the court would have to play a proactive role. Judicial activism should come into picture and give guidelines and make laws gender neutral at one stroke. This is the only solution they have.
Right, sir. So we have a question which is not the majority opinion. So her question is that according to her, homosexuality and like this is something which is unnatural because people who are homosexual they cannot reproduce. So isn't legalizing same-sex marriage is basically going against the nature
I
of
know
a
this question. I
society?
was waiting for this question, in fact. This is a notion, the ancient Christian notion, in fact, the Western notion that the sex should be done only for procreation. I don't think this concept is tenable in the present times. I mean, sex is a basic right. It is equal to roti, kapda, and makan. It is not just for procreation. Sex is also basic necessity. It is not just for procreation. So it based on the notion that sex is only for procreation. On that basis, the sodomy should also be penalized. Even on that basis, the heterosexual people who are indulging in other kind of sexual activities like sodomy, they should also be penalized. Then why we have discrimination? It is a
Right, sir.
old notion. At present, in present times, it not stand good. I guess it is my view. The person who has asked this question might have his own view, but sex is not only for procreation. We are talking this in 21st century. It is an old notion. It is an old Catholic Christian notion that sex should only be for procreation. In fact, other religious beliefs also believe that it is should only be for procreation. And all other sexual activities apart from sex, that is penis, vaginal sex. Apart from that, all other sexual activities are unnatural. So, in that sense, all heterosexual couples are also get should also be penalized in that sense. It should be applied to them too.
Yes, completely. Again, one more question, which is on the similar lines, which says that as the court has already recognized same sex, like people are allowed to have sex with the same gender, so why do we need to legalize marriage? Isn't this enough?
That's what I have said. Why there is need to legalize? Because mere recognizing same-sex couples, mere decriminalizing same-sex activities won't solve the problem. It will continue to hamper the constitutional and human rights of LGBT community, the homosexual community. It will continue to hamper their right to life, their right to personal liberty, their right to make decisional autonomy. They have their own autonomy to decide for themselves, which is also part of right to life and personal liberty. They have right to freedom of expression. So these rights would violate on a regular basis. They will not have their rights. Then they will cannot be termed as equal citizens of this country. They will become equal citizen or equal member of the Union of India only they when they their rights are recognized as same enjoyed by heterosexual couples. They will continue to face problems. It is it I The day when Navjot Johar case was delivered, the judgment was delivered. I knew that the soon within few days, this petition would be filed in the honorable court regarding recognition of same-sex marriage. Because without recognition of same-sex marriage, Navjot Johar judgment would be a futile judgment. It would not hold any good for the LGBT community. It would not make a situation much better for them. Because what they would be living like a uh, uh, live-in relationship in which the heterosexual couple lives, and in that sense also they don't have all those rights which the live-in relationship heterosexual couple enjoys. So to enjoy all the rights, to enjoy the personal liberty, to enjoy right to life to its fullest, right to life with decisional autonomy, right to life with dignity, this need to be recognized. This need to be same-sex marriage need to be recognized. It is a need of the hour.
Yes, so that was a
Then how,
remarkable point, sir.
if someone wants to have a family, someone wants to have child, but, apart from adoption they can have child through surrogacy. We have the science has developed to a great extent. So apart from adoption, they can have child through surrogacy, not an issue. So the heterosexual couple would not be able to enjoy life. A homosexual couple would not be able to enjoy life in the same ways heterosexual couple enjoys. So it is the need of the hour.
Right, so because in case if these rights are not conferred to the community, then we are technically treating them as second class citizens.
Exactly. They are treating them as second class citizen. Then they will not be equal citizens of this country as heterosexual couples are,
Right, completely, sir.
and which would be, I guess, I would say, fraud on the constitution itself.
That's right, sir. So we will be dealing with the last question for today. So we have a
Yes.
question, sir. An attendee has this opinion that while with legalizing same-sex marriage, it requires a lot of other things, just succession, adoption, and all. So this would be a lot of changes for the society to handle mentally, physically. whatever capacity. So she feels that there should be a separate, complete separate legislation that should just cater to the LGBTQ plus community, and the regularized law shouldn't be disturbed or changed. What do you think
I guess
about that?
this can also be done. In fact, I have never. In fact, I myself have not given thought to it. But if we can make laws gender neutral, in the laws which require, they will require a lot of changes. I agree. So yes, this is in fact a good idea. But I guess it would make them a separate class. It would discriminate them. Why not rather incorporate them within the same set of laws, rather than making a special laws for them? I know there might be some difficulties in changing the laws, but it is not something very difficult which our lawmakers or which our bureaucrats cannot do. The law ministry has got a lot of capable persons, lot of legal experts who can draft such laws. So I don't think it will be a problem. If other countries can do it, why not we? Just because there might be some difficulty in framing such laws, it doesn't mean that we cannot do we should make special laws for them and make them feel different from us. Rather, we should make laws which should govern everyone, including homosexual as well as heterosexual. From tomorrow, there might be demand that there should be special codes for them. So rather than this going for a separate, which though can be done, but if they are incorporated within the same set of law, then why to make separate laws for them?
Right. So that's typically protecting and promoting the spirit of equality.
Yes, exactly. There is no other in that case. If we make laws for them and make same set of laws gender neutral, there is no other.
Right. So I think we have dealt with all the questions which were posted in the chat box. Thank you for the questions. So we've reached the end of this incredible webinar. In the current social landscape where same-sex marriage remains a pressing issue, this webinar holds immense significance. Before we bring this webinar to a close, I would like to take a moment to express my deepest gratitude and offer some closing remarks. On behalf of the entire council, I would like to extend a heartfelt thank you to our esteemed keynote speaker for gracing us with his presence and sharing his invaluable expertise and insights on this issue. Your presence here today has been an inspiration to all of us, and we are immensely grateful for the in depth knowledge and passion you've brought to this webinar. Your expertise in this field has provided us with a comprehensive perspective, enabling us to gain a deeper understanding of the legal aspects and social implications of same sex marriage. I would like to thank the President of the National Judicial Reform Council, Ms. Aishwarya Bhatia, and Vice President, Ms. Devanshi Parashar, for making this event happen. I want to thank all the council members who really worked hard to make this event successful. We extend our heartfelt gratitude to our esteemed audience for their unwavering support and active participation throughout this webinar. Your presence and engagement have been instrumental in making this event a success. Thank you so much, everyone, for joining in. Have a good day. Thank you so much, sir.
Thank you again for inviting me. I guess this would have given new insight to you, all the audience, and a new perspective looking at the LGBT community's rights. Thank you again.
Yes, sir. We've learned a lot today.
Thank you so much.
Thank you so much, sir.